Hello, everyone, and welcome to our 10th and final episode this season of Space Law Webinars at the Law, Technology, and Warfare Research Cell at the U.S. Air Force Academy. I'm Major Matt Ormsbee, and I'm pleased to bring you another webinar on space law and policy. For our last webinar of the season, we're very excited today to welcome Professor M.J. Durkee. Professor Durkee holds the William Gardner Hammond Professorship in Law at Washington University School of Law in St. Louis. She's an expert in international law with a focus on international legal theory and specialties in business, environment, and governance. Professor Durkee investigates the public-private interactions that produce and interpret international legal norms and considers how legal and institutional design choices affect processes of international cooperation. Her scholarship has appeared in the Yale Law Journal, Stanford Law Review, Virginia Law Review, American Journal of International Law, and several other prominent peer-reviewed and student-edited publications. And her volume, States, Firms, and Their Legal Fictions, was published just earlier this spring with Cambridge University Press. Additionally, she serves on the board of editors of the American Journal of International Law. We're very honored to welcome her today as she addresses some of her newest research regarding space law and broader themes about international lawmaking. As always, as we go along, if you have any questions, please feel free to type them in the box, and we'll try to reserve time at the end to answer all of them. Professor Durkee, thank you so much for being with us today. At this time, I'll turn it over to you and let you begin your presentation. I may have to make you a host one more time. I apologize for that. Let me see. Okay, now you should be able to turn on your camera and everything should be fine. All right, I can
Yes,
see you
great.
just
We're
fine.
good.
Okay,
All
over to you,
right.
ma'am. Thank you.
Yeah. Well, thank you. Thank you very much, Major Ormsbee. It's a pleasure to be here. I appreciate the invitation, and I took a look at some of the prior Zoom or the YouTube recordings of the prior lectures, and it sounds like it's been a fantastic season this year with some really good thinkers and a really great set of diverse topics. So it's a privilege to come at the end of this because all of you who have been following along this whole time are up to speed on a lot of really interesting developments in international space law, which will present sort of a nice foundation for what I'm talking about. And that is, I'm going to look at the development of international space law as a whole, and what it's saying about the development of international law in the 21st century. So yes, as Major Ormsbee said, I'm MJ Durkee. I'm at Washington University in St. Louis. I'm a professor of law, and I'm an international lawyer and a theorist. So I'm not a space law specialist, but instead an international law generalist. And my research is focused on these interactions between public and private actors in creating and developing international legal norms. So in other words, governments and the commercial sector. And I've been interested in international space law as a case study for broader international legal trends and the relationship between those two topics. So let me pull up some slides here, and then I'll get started here. Let's see. Okay. So let's see. So are my slides showing?
Yes, ma'am, I can see them.
And are they showing in the presentation mode?
Actually, not yet.
Okay, let's see. I'm not sure if I quite know how to do that. Let me try to share again.
Maybe if you click on the bottom.
Yeah, it's giving me the presentation mode in a different screen. So maybe I don't have it quite set up correctly. Yeah, I'm not sure. I mean, I could present this way, but it's kind of nicer for the viewer if I can get it the other way. Let's see if I can try this one more time.
Yes, ma'am.
Here, let's try this. Oh, I see. Here we go. Okay, I think I got it now.
Perfect. Yes.
Okay. Great. Are you seeing the slides? Sorry.
Yes, ma'am. Perfectly.
Yes. Okay, great. Okay, great. Okay, good. Okay, so let's see. So my remarks today are based on a recent paper, and actually you can find it. So if you're interested in this topic, this paper is available open access on SSRN and on this link here, which is the scholarship repository at the University of Pennsylvania. Okay, so as you can see, my claim here is that space law's current moment is reflecting international law's current moment. That is, space law is a good case study for changes in international lawmaking over the last century, in that it shows in a pretty stark fashion some of the differences between what I call paradigmatic 20th century lawmaking and the very different forms of lawmaking and norm development that we're seeing in the 21st century. And it helps us project where some of these 21st century paths might take us. So let me give you the conclusion up front, and then I'll take a few minutes to talk about 20th century, paradigmatic 20th century ways of making law, so we can put these new modes in context. Okay, so here's the conclusion right up front. I think there's three trends that we're seeing in 21st century international space lawmaking. And maybe you can give it some thought as I'm speaking, and if you have reactions, you can let me know in the Q&A whether you're seeing this too or have a different perspective. So here are the three trends that I'm seeing. First, interpretive competition between the United States, China, Russia, and others. So these rivals are competing over how to interpret existing international space norms. They're trying to develop international law's evolutive or practice-based forms. And second, this is producing fragmentation of law. That is, unresolved differences of opinion about what the law demands. And it's also causing actors to turn to other kinds of norms, non-binding norms, pledges, codes of conduct, standards, and so forth. And third, this interpretive competition and this turn to non-binding norms is giving the opportunity to a wider range of actors, including commercial actors, to participate in the norm development process. So they have many more opportunities to engage in the development of international laws and norms. So the bottom line here is that 21st century law is a period, it's ushering in a period of contestation, right? We are having lots of claims by lots of actors. And I think that there's three likely results here, including an entrenched contestation and fragmentation of law that endures for a long time. Another possibility is pluralism, where actors find ways to navigate the diverging bodies of norms and understandings, or coalescence around new norms, maybe norms that are first developed as non-binding codes. Okay, so that's a teaser. Let's rewind and get into some more detail. So the existing international space law on the books is in many senses paradigmatic 20th century lawmaking. So what was 20th century international law? Well, we had these major rounds of institution building after the World Wars. After the atrocity of the World Wars, there was this grand lawmaking moment where many different countries came together to create the UN system. You see here the signing of the UN Charter in San Francisco in 1945 after the World War II. This period gave us human rights treaties, humanitarian law, criminal law and institutions, economic instruments, including the Bretton Woods instruments and the General Agreement on Tariffs and Trade. So this was a grand period of codification and of institution building. Then, of course, the Cold War slowed the pace of development of international law, but some areas still continued, like international environmental law came to arise during this time. So then after the end of the Cold War, we had another flourishing of international law, mainly multilateral governance through the United Nations and other institutions. We had another period of ambitious international lawmaking. So the 20th century was a codifying and institution building century, principally in the post-World War II context. Its central project was to develop international law through treaties, multilateral treaties, treaties for general subscription, and through international organizations, and it was focused on the rule of law. focus on international governance by the rule of law. We're seeing something different in the 21st century. We're seeing a retreat from these multilateral aspirations. This retreat has been precipitated by failures of the international rules-based order, failures to prevent illegal acts of armed aggression, several of which are still occurring, failures to coordinate a sufficient response to the global pandemic, failures to agree on the values that should regulate global markets, failures to achieve distributional fairness to address the needs of the global south, and of course, failure to respond to the existential threat of climate change. So these failures have prompted waves of populism and isolationism, defections from major multilateral efforts in world trade, and international criminal law and other areas, and really dimming prospects going forward for major new multilateral agreements. So let's consider, against this backdrop of 20th century versus 21st century international law, let's think about the development of international space law. So I'm characterizing international space law as classic 20th century international lawmaking. As everyone listening knows, international space law consists of 5 major multilateral treaties, which entered into force in this brief 12-year period, beginning in 1967. And of course, these treaties were negotiated between the principal Cold War powers, the United States and the Soviet Union, and their proxies. And at this time, these two were in competition to get to space and to get a person to the moon. So as we all know here, the first and most foundational is the Outer Space Treaty, which has been called a Constitution for Outer Space. And it has a number of broad principles, like you see here, Article 1. The treaty's main goals seem to be to preserve free access to space, to bar claims of sovereignty over space or objects in space, to lay groundwork for cooperation and the responsibility of spacefaring nations for their activities in space, and to prevent the weaponization of space, prevent the use of outer space to create an advantage for one of the great powers. So why do I characterize the Outer Space Treaty as classic 20th century international lawmaking? Well, it was formed through a multilateral process. It commits all parties to the same general principles. It aims for universal subscription. And it has mostly succeeded in the way that many 20th century treaties did to get broad subscription. It has 112 parties, including all the major space powers. And what this treaty does well is what many 20th century framework treaties do well. They lay down general rules and principles to guide further multilateral cooperation. And its aims are these classic 20th century aims: to articulate common norms, to avoid hot wars, and to provide a framework for collaboration. Of course, what it doesn't do is to offer particularly specific regulatory guidance, though some of the later treaties do fill in details about liability for damages caused by object launched into space, registration, et cetera, et cetera. Okay, so of course, one of the pressing questions of our day is to answer this whole slew of questions for which these classic 20th century treaties don't provide sufficient specificity. And as I said, I'm a generalist, not a space law specialist. So I will leave it to the specialists to answer questions about what exactly those rules are. What rules do we need? I'll just say that a lot of people seem to be observing now that the proliferation of actors making plans for space, the proliferation of new plans for space, the new capacities in space, new ambitions for space are all creating a demand for more specific regulation. There's questions including environmental and sustainability questions. How can we protect the space environment from contamination, dangerous orbital space junk, harmful mining practices? There's questions about legal rights. How might commercial actors secure rights to outer space resources, or protect mining sites, or obtain regulatory certainty to persuade investors to buy in? There's questions about remote sensing and satellite communications. How can we avoid strategic use of satellites to interfere with on-Earth activities? How many satellites is too many? Do indigenous people and on-Earth astronomers have any claim to a dark night sky? There are many security questions, potential for tourism, and the list goes on, as you listening likely all know quite well. So while the Outer Space Treaty offers principles, that treaty, together with the rest of the 20th century space law treaties, don't seem to be fully meeting the moment. They didn't anticipate all these plans for space, nor do they offer specific regulatory regimes to respond to them. So of course, this context is not unique to space law. This context where we're seeing new activity precipitating new regulatory demands is not at all unique to space law. New tech capacities and new problems produce successive demands for law in many areas. What has changed and seems to still be changing is the international response to those regulatory demands. So while the ideal type 20th century response would have been to convene a multilateral conference to negotiate a new treaty or develop a draft text within the General Assembly Committee, like the UN's Committee on the Peaceful Uses of Outer Space, COPUOS, the 21st century is witnessing something new. So this new, more pessimistic period is marked by the hollowing out of existing commitments, threats of defection, defiance of core norms, and an increasing multipolarity that serves to make deep and broad cooperation seem more impossible. Governments are preoccupied by new wars, security concerns, migration, tech challenges, realignments of power. They're defanged by populism at home, and so forth and so on. So in this context, space law is offering a case study in how else actors might try to obtain the legal groundwork that they seek. So when a multilateral treaty is off the table, but law is needed, what do actors do? So space law, I think, is offering us a case study. Looking at these 21st century processes of international lawmaking from the perspective of space law reveals three themes. First, states are engaging in interpretive competition over the existing rules. Second, we're seeing the development of parallel and alternative lawmaking streams that are producing fragmented and non-binding norms like codes of conduct and pledging platforms. And third, these interpretive contests and non-binding platforms are offering many opportunities for non-state actors, specifically commercial actors, to also get involved in the international lawmaking process. So let's focus first on these interpretive contests. We think of international law as treaty-based, partly because the 20th century was such a codifying moment. We were making so many treaties, and partly in this context because treaties form the foundation of space law. But we can't lose sight of the fact that international law can also develop through practice. Common law lawyers here in the United States and elsewhere can think of this in the way we think of the common law. That is, for some bodies of law like torts and property, only some rules are written down in statutes. The rest develop over time through precedents. International law also develops over time through precedents, and this precedential system of legal development was the main source of international law before the explosion of treaties in the 20th century. So one way to look at how international space law is developing now is to see it through the lens of this practice-based development. So let me get more specific about what I mean by practice-based development. I mean two things: the interpretation of treaties and customary international law. So treaties are to be interpreted not just in light of the ordinary meaning of their terms, in their context, and in consideration of its object and purpose. Instead, treaty interpreters are also instructed to take into account, first, any subsequent agreement between the parties regarding the interpretation of the treaty or the application of its provisions. So treaty interpreters can look to later agreements, subsequent agreements, and they can also look to subsequent practice in the application of the treaty, which establishes the agreement of the parties regarding that interpretation. So they can look at later agreements and later practice to try to figure out the correct interpretation of an earlier treaty. This is in the Vienna Convention rules, classic international legal rules about how to interpret a treaty. This subsequent practice can be used to resolve an ambiguity in the treaty, or confirm the meaning of a treaty term. And what is this subsequent practice? Will include executive, legislative, judicial, or other functions. So the kinds of things that governments do. We're looking at activity and statements of governments. So this is treaty interpretation is informed by subsequent practice. Well, it turns out there's a second source of international laws, practice-based. There's a second practice-based form of international law, and that is customary international law. And any of you who has taken a basic class in international law will know about customary international law, right? So customary international law develops through the relevant acts of nation states. They call this practice and opinio juris, or evidence that nations believe that this relevant practice is legally required or permitted. So again, the bottom line here, that's a little bit in the weeds and technical, but the bottom line is that international law can develop not just through treaty conferences, but also through the relevant activity and statements of governments that can interpret existing treaties, and it can create new laws. All right, so with that as a backdrop, I want to explain my view that one of the things international law, space law is showing us is that governments are doubling down on these practice-based means of developing international law. So here's an example. Think about the debate you probably are familiar with from a prior lecture and elsewhere. But think about the debate about whether mining is permitted on the moon or asteroids or other places. So we have an article in the Outer Space Treaty. We have Article 2 of the Outer Space Treaty, which says outer space, including the moon and other celestial bodies, is not subject to national appropriation by claim of sovereignty, by means of use or occupation, or by any other means. And then, of course, Article 6 makes state parties responsible for anything that commercial actors might be doing in outer space. Okay, so what exactly does that mean? There has been a debate. There has been a debate in the past. Perhaps it's now fading away, but some probably would not agree that this is a debate is fading away. There's a debate about what it means, what this prohibition of national appropriation means, right? So one possible interpretation is that space resources may not be appropriated or subject to any claims of ownership, whether by governmental or non-governmental entities. And this interpretation is bolstered by some other things in the Outer Space Treaty. The idea that exploration and use of outer space shall be carried out for the benefit and in the interest of all countries, which might be consistent with a lack of ownership claims. The Moon Agreement, developed a decade later, might be confirming this restrictive interpretation because it says, more specifically, neither the surface nor the subsurface of the moon nor any part of it or natural resources in place shall become property of any state or non-governmental entity. Okay, so we have one side of this debate saying there's no property, you can't have any property rights in outer space, you can't have any property rights on the moon, etc. But of course, that there is another opinion here as well. So there's a more permissive interpretation of Article 2, which says that this provision merely stipulates that nothing that anyone is doing in outer space will count as national appropriation. So if someone's going to the moon and setting up a mining operation, that doesn't mean that that entity is claiming the moon or that portion of the moon as under the control or sovereignty of a particular country in the United States. So it's a stipulation that none of this activity shall be understood as national appropriation. And this is also bolstered by some other things in the Outer Space Treaty, like the fact that the treaty does talk about the use of outer space, which must mean that parties are permitted to use it in some way. And also folks on this side of the debate say, well, the Moon Agreement shouldn't be used to interpret this provision because not many people actually joined the Moon Agreement. So it was not a successful treaty, suggesting there wasn't consensus on this point. Okay, so my point here is that there is a debate over the meaning of this treaty text. And I think it's really clear that a whole number of things the United States is doing are designed to force international law to develop through these incremental practice-based forms rather than the legislative form that emerges from multilateral treaty making. And it's quite a campaign. Okay, so it's trying to establish subsequent agreements and subsequent practice that can be used to interpret the Outer Space Treaty. And it is also trying to establish customary international law in this area. And I think that we see at least 4 ways the United States is doing this. There might be more ways, and if you spotted one, I'd love to hear about it. Okay, just a second. Okay, so we have the 2015 legislation, which you're probably familiar with, the Commercial Space Launch Competitiveness Act. We have executive orders, we have Artemis Accords, and actual offers to make purchases from commercial operators, materials to be collected from the moon. Let's talk through this briefly because I think it's really interesting. Okay, so the 2015 Commercial Space Launch Competitiveness Act. As you know, this was a piece of legislation in the United States, which said, the operative provision is here. A United States citizen engaged in commercial recovery of an asteroid resource or a space resource under this chapter shall be entitled to any asteroid resource or space resource obtained, including to possess, own, transport, use, and sell the asteroid resource or space resource obtained in accordance with applicable law, including the international obligations of the United States. So here, the United States is declaring that recovery of resources is permissible. But the most interesting thing about this provision is that last line, obtained in accordance with applicable law, including the international obligations of the United States. So the United States is setting out to interpret the International Space Treaty, right? It's setting out to say these things are permissible when obtained in accordance with international law, which means that the United States is declaring that international law permits use of space resources. All right, so if you're thinking about the development of international law through its practice-based forms, it's quite obvious that this is state practice, right? This is a legislative proclamation about what the United States believes international law means. All right, so then the U.S. digs in. Here we go. Executive order in the year 2020, saying Americans should have the right to engage in commercial exploration, recovery, and use of resources in outer space. All right, so that doesn't really interpret international law, but what's really interesting about this executive order is this portion about the Moon Agreement. So the U.S. says that there has been some uncertainty regarding the right to recover and use space resources, and that uncertainty has discouraged some commercial entities from participating in the enterprise. So the order declares that Americans should have the right, and and more significantly, it specifically disclaims the Moon Agreement and its more restrictive policy on use of resources. It claims that the United States does not consider the Moon Agreement to be an effective or necessary instrument to guide nation states regarding the promotion of commercial participation in long-term exploration, scientific discovery, and use of the Moon, Mars, or other celestial bodies. Accordingly, the Secretary of State shall object to any attempt by any other state or international organization to treat the Moon Agreement as reflecting or otherwise expressing customary international law. So we know that there were not many participants in the Moon Agreement. It was not successful like the Outer Space Treaty, but the US is acknowledging that if people start following the rules in the Moon Agreement, then international law will develop in its practice-based forms to crystallize this customary international law rule that that adopts the Moon Agreement's approach to mining activities. And so the US is protesting, says we are going to protest every time somebody invokes the Moon Agreement so it doesn't become law. Okay, so then what about the Artemis Accords? Fascinating Artemis Accords. Okay, so the Artemis Accords are, I think, so clever by the United States because they look like treaties, they look like international agreements, but they aren't. This is a unilateral statement that the United States has has developed, and now it's trying to use a contractual approach to get other countries to sign on. So how does this relate to our debate here? So the Artemis Accord affirms the importance of compliance with and the desire to implement the provisions of the Outer Space Treaty. So at the outset, the US is saying, hey, we're just interpreting existing law. We're not trying to create new law here. Why is this important? It's important because then the US can claim that this subsequent agreement can go back and interpret the Outer Space Treaty, that the Outer Space Treaty should be interpreted according to its practice-based forms. Okay, the Artemis Agreement provides the operational implementation of important obligations concerned in the Outer Space Treaty. Again, the same. Okay, and then as far as mining, the signatories affirm that the extraction of space resources does not inherently constitute national appropriation under Article 2 of the Outer Space Treaty, and that contracts and other legal instruments relating to space resources should be consistent with that treaty. So the United States is trying to establish that the accords are interpretive and not constitutive, and then trying to again stipulate how the U.S. Interprets the Outer Space Treaty. And as the United States has been going around and trying to recruit other signatories to the U.S. Artemis Accords, it can invoke their agreement as further evidence of the U.S. interpretation of the Outer Space Treaty. Recently there was a launching ceremony in late 2020 of the Artemis Accords, and a high-level NASA administrator said, "We're creating a track record, a norm of behavior that will influence the entire world to proceed with the transparent, peaceful, and safe exploration of space." So a track record and a norm of behavior. The US is specifically trying to develop law through its practice-based forms. It wants the accords to interpret the Outer Space Treaty, and it wants the accords to establish the practice and opinio juris that are needed to make new customary international legal norms. And I'm just focusing on mining here, but of course the Artemis Accords goes further and establishing other norms about, interoperability, sustainability, and so forth. And lastly, really interestingly, the US has recently offered to purchase materials from commercial operators that are to be collected from the moon. So it's announced that companies that can collect a little bit of lunar soil from the moon's surface and provide imagery to NASA, then NASA will actually purchase that material. The company doesn't have to transport it back to the US. It will just purchase the material in its current location, but the title to this material will transfer to NASA. Why is this important? Well, it is again developing law through practice, right? The US is engaging in the practice of purchasing material and owning material and having extractors able to sell that material. So if you're thinking about international law's practice-based forms and you're looking at the beliefs and the practice of governments, this is clearly a practice of a government. It's a really, really interesting concerted effort here to develop international law's practice-based form. The US doesn't have to do this. What could it be doing instead? It could be pushing for multilateral solutions. But because multilateral solutions seem to be off the table in this pessimistic era of the 21st century, then instead the US is resorting to this older playbook, this practice-based legal development playbook. All right. So that's the main theme that I wanted to focus on, is this development of law through its practice-based forms. But this gives rise to a couple other trends as well. The first is that the fact that actors are engaging in parallel and alternative lawmaking projects, producing fragmented and non-binding norms. So what do I mean by that? Well, the US interpretive and custom forming project is really catalyzing vigorous protest and responsive efforts by geopolitical rivals, namely China, It used to be, we thought that Russia was a big player here. Maybe Russia's space program is falling off a little bit, and China is the main country to watch. But we see responsive efforts by China. Of course, we saw vigorous critique. China likened the Artemis Accords to the enclosure movement in the 18th century Britain, during which common land was privatized for the benefit of the wealthy. Russia stated that attempts by the United States to expropriate resources would be tantamount to an illegal invasion. And both have protested about process as well as substance, complaining about US domestic level efforts, legislation like the 2015 legislation, which of course was also adopted by a number of other countries, including Saudi Arabia and UAE. Well, the UAE and Japan and two other places that you could probably tell me that I'm not remembering, like the Netherlands maybe. In any case, China is protesting about these unilateral efforts in the domestic law of particular countries, rather than the use of these classic 20th century multilateral lawmaking processes. And even more interesting, this new bloc, the Russia-China bloc, maybe led by China now, seems to be trying to match US lawmaking efforts with their own evolutive lawmaking efforts. Recently, the two signed their own memorandum of understanding, committing to jointly construct a lunar station. And we have a number of signatories now to this, including Venezuela, Azerbaijan, Thailand, Turkey, South Africa, Pakistan, Belarus, Egypt, Nicaragua, Serbia. You get the picture of who's joining this coalition. And I think this list is current as of this month. So their emphasis in declaring this alternative lunar program, the alternative to the Artemis program, is that this is for open access research, not commercial appropriation, right? So there's a separate interpretive effort being made here. This is the interesting thing, is the Chinese commercial sector does seem to also be growing. So perhaps they'll have to reconcile these two messages that they're sending about non-appropriation and commercialization. But in any case, the Russian and Chinese protests over US practice are meaningful in international legal terms, in that they should prevent the development of customary international law or the interpretation of the Outer Space Treaty in the US format, because there's a alternative on the table, right? So a interpretation is only valid, a customary law only forms when you have a sufficient uniformity of practice, and they are interfering with the uniformity of state practice and opinio juris on the mining question by protesting and creating alternative practice. So that's what I talk about when I talk about fragmented norms, different ideas of what the law requires that have not been reconciled. So, so as we're seeing this fragmented and divergent lawmaking, with both sides using the classic rules to produce different substantive results, where we might have polarization of nations into two or more camps, with each side advancing a fully different version of what international law requires. That's a fragmented international order. And part of what that fragmented international order is producing is, oh yeah, here, there's a slide I missed. China's International Lunar Research Station offers an alternative to the US Artemis program. So part of what this fragmented international legal order is producing is a turn to other modes of creating international legal norms. So here we see an announcement of Zero Debris Charter, aiming to boost international cooperation on cleaning up Earth's space junk problem. So what is this? Well, this is what I call a pledging platform. So we have nations and private actors getting together to create articulate some sort of mode or norm of conduct, and then individual actors, both states and private actors, can sign on to pledge that they are going to do something about this common problem. And you see this a lot in climate change. Of course, you have the Paris Agreement is in a pledging-based format, and you have other climate rules being executed in a pledging-based format. And pledging is coming to space law as well. So instead of having a multilateral agreement, you have every individual making individual pledges, individual company or individual states. And you also see codes of conduct, non-binding principles, and so forth. All right. So I know that I've spoken for quite a long time. So I'm just going to talk briefly about the last trend I think that we're seeing, and that is that these interpretive contests and these non-binding modalities are expanding opportunities for non-state actors, mostly commercial actors, to influence international lawmaking processes. So in previous work, I've called this interpretive entrepreneurship, right? Lobbying by private actors that is directed at the interpretation of existing law. And I would also expand this to say that they're also involved in producing these pledging platforms and producing these alternatives to law, these codes of conduct and non-binding sets of norms. So we know that the commercial space enterprises engaged in significant efforts to lobby the US Congress to encourage it to pass the Space Act of 2015. And they throughout were engaging in this interpretive activity. They were making the case to Congress that commercial mining was permitted under the Outer Space Treaty and that the legislation would clarify the correct interpretation. They also nudged the United States by putting it in the US national interest to adopt commerce-friendly interpretations. The carrot they're offering is a boost in US GDP and soft power if they're successful. And the stick is a threat of regulatory arbitrage. That is the fact that they could simply move on to a more permissive regulatory environment if their home state is not offering the necessary regulatory framework. And congressional testimony offers a lot of evidence of this nudging behavior. Okay, so the point is that these practice-based forms of lawmaking attract lobbying by private actors because private actors have many opportunities to weigh in on the development of norms, not just at the initial treaty conference, but over time as law is developed in these practice-based ways. Okay, what does this all add up to? Well, as I said, I think space law is a case study for international lawmaking. 21st century space law offers a glimpse at one of international law's possible futures. So what do international actors do when regulatory demands outstrip the capacity for multilateral treaty making? Space law's answer is that actors find practice-based ways to develop norms. This can produce separate lawmaking streams, alternative claims about what law is, which can in turn offer many opportunities for non-state actors to shape the process. This can also produce various other forms of soft law, guidelines, pledges, etc. We could have a future of fragmentation, pluralism, coalescence around new norms, etc. And lastly, well, two last points. Okay, penultimate point, I think that the playbook that it's emerging reduces distinctions between state actors and private actors. I think that a lot of the significant activities the US is engaging in draw from the private law toolbox, contractual toolbox. And also with private actors getting involved in these processes, we're reducing the special status of states in public lawmaking. And last, I do think that these modes show that even if international actors don't think it's feasible to engage in multilateral treaty cooperation, they still care very much about international law. So all these actors, these public and private actors, are haggling over legal meaning. They're all trying to justify the activities of the new commercial space age with international legal terms, rather than dismissing its importance or claiming that might makes right. So in the future that space law is showing us international law maintains its relevance, at least as a legitimizer, even when the parties are disagreeing over the substance of the rules. Okay, that's what I got for you. And I'm looking forward to hearing comments. Let me see if I can stop this and turn on my video. Here we go.
Wonderful. Thank you so much for the presentation. We, of course, have time for some questions. Want to thank you right off the bat, though, for your presentation and your thoughts on space law and broader themes of international law and many of the good points you raised about these trends that we're seeing in space law today. So yes, as you say, we'll turn to questions from attendees. Anyone can add questions if you've been holding on to them. Type those in and we'll pose those questions time permitting. I see we have a few already. So one person asked, seems like we have to work with what we have for treaty law today, and that there isn't a big appetite for new treaties. We had a reason for that and those major agreements after World War II, but we're in a very different situation today. So based on that, if we're not going to have new big agreements, do you think that we'll see more and more fragmentation of legal interpretations going forward?
Yeah, so I think so that's a great question. That's a great question. My crystal ball doesn't show me what the world looks like in 50 to 100 years, but I think there's what we can see is some very distinct possibilities, right? And one possibility, so in a way, this contestation over law is part of a really normal process, right? So someone will make a claim about what law requires, and then someone else will either go along with that claim or react to it. And this is a claim and reaction process that produces customary international law over time. So part of what we might be seeing is just a short period of contestation leading to coalescence around new norms. So one thing that I see is that all of this will lead to more stable interpretations that everyone shares, right? And it's part of a normal process happening now. Now, you know, this process is not necessarily good for everyone. It privileges those who have more current capacity in outer space. It privileges those who have strong foreign ministries, strong state departments, as the US does, and can make a big and can protest when rules are not developing as they'd like, and make all these concerted efforts, as the US is doing, to develop the rules in a particular way. But what it could lead to is stable customary international law or stable interpretations of the existing law, which will then lay the foundation for future treaty making if we want to, because everyone's already sort of agreed on the principles of the rules. So one future that is possible is that this is all part of a process that leads to another wave and another round of lawmaking, and that is possible, and it's possible in a number of different areas of international law. Another possibility is that this is we see entrenched fragmentation. We see increasing divergence between different blocks in the US, and leading to various things, leading to more hot wars, leading to another Cold War. And we have a longer period of contestation, of entrenched differences of opinion, which is a scarier future, right? That's not a future of a rules-based international order. That's something else, right? And it could lead to some major issues on Earth or outer space that will then have to give rise to a post-World War II sort of return to rules because of a major catastrophe. So that's a darker vision of the future, but it's possible. A third thing I see, besides coalescence around new norms leading to new lawmaking, or continued fragmentation potentially leading to more catastrophe, a third way would be a change to different ways of doing law. And that's what I think might be happening with these pledging platforms and codes of conduct. What we're seeing is that these ways of making legal norms or quasi-legal norms are attracting attention by both states and private actors. And you see pledging happening in places like Davos, World Economic Forum, and you see pledging happening in places like climate conferences. And now you're seeing pledging happening in space law as well. And this is not law-based in its traditional forms, because it's not governments and government officials sitting down at a table and negotiating rules that then become binding. It's instead this kind of looser form of commitment where individuals are committing for themselves. And by individuals, I mean nations, private companies, anyone else who has a constituency to pledge for, cities, and so forth. And so these new ways of pledging seem to be breaking through the formal lawmaking log jams, right? People are willing to do it because all they're doing is pledging for themselves, not binding themselves to something in the future. This sounds like a poor substitute for law. I agree, but it's possible that this is another way to create norms of behavior that will eventually get people on the same page, where we can come in and create binding law around what people have already sort of gotten used to agreeing to do over time. So those are three possible futures I see from the current period of contestation.
Thank you, ma'am. One other question we had from an attendee is, one downside of commercial first space strategy is the culture that comes with it of greed is good. So commercial actors may be motivated by profit and not necessarily sustainability or societal advancement, cooperation, things of that nature. So the question is, how should we negate some of those downsides that may come with this kind of space strategy that either we're choosing or is just we're sort of organically walking into with our space laws and policy?
Yeah, so I agree that this is a concern. I tend to be a little bit of a pragmatist in that or maybe a theorist is a better way to say it, and that I'm trying to understand what's actually going on more than I'm trying to make a value judgment about what's going on. But I kind of agree that this is a concern, right? That the governments at least have some sort of ostensible pledge to trying to act in the public good. They have some sort of accountability to their constituents, whether that be through an elected process or through in an authoritarian system, the threat of regime change, right? They at least have some sort of accountability to people whose good they're trying to act in. But of course, when commercial actors get involved, their accountability is to their investors, right? And so if investors are concerned about the bottom line, then the commercial actors are sort of structurally amoral, right? They have no reason to look out for the public interest. So there's two ways to rectify that, right? To either create a stronger regulatory system, which governments don't seem to be super inclined to do, or to somehow put it in the firm's best interest to engage in a common strategy. And so where you see commercial activity for the common good is where they can see how it's actually aligns with their bottom line, right? So why do we have action on orbital debris? Well, companies involved in setting up satellites might be concerned about the Kessler effect, right? Why do you have action in the green energy transition? Well, the companies that are buying in are the ones that are seeing a potential bottom line reason to do that. So yeah, so I mean, I don't have a lot more to say besides that I agree with this as a concern. And that's the whole idea behind a rules-based order, that we can create rules that are for the common good. And ideally would be doing that right now. However, in these 21st century circumstances, we don't have strong international law. We don't have we don't have a lot of energy by local governments or national governments to create the rules that we might need to ensure sustainability and so forth. So what do we do about that? I mean, that's a much bigger question than this webinar today. But on my theme, I think that space law is not unique here, right? This is a much bigger 21st century trend that you're seeing in in human rights, in international criminal law, in the laws of war, humanitarian law, and so forth. In all of these areas, environmental law, climate change, in all of these areas, we're really struggling to uh, ensure, as the questioner said, sustainability, societal advancement, human rights, and so forth.
Thank you. If you'll humor us, maybe we have one more question we can squeeze in before the end of the hour. One of the attendees asked, are interpretive contests that you spoke about, are those always going to be potentially unfair because they basically benefit the largest and richest states? So the US, of course, we have the power to draft and socialize our Artemis Accords, but a much smaller state, for example, simply doesn't have that and doesn't have as much say. So is there always going to be some element of unfairness when it comes to this?
Oh, I think it's absolutely the case. There's a certain amount of might makes right here. That companies that are have spacefaring capacities, that orbital launch capacities, countries that have powerful foreign ministries and state departments that can really engage in making a lot of comments about what they believe international law required are going to be the winners in a system like this. And this is another reason why at the end of World War II, we really strove for multilateralism, like full multilateralism, agreements that everyone could join. Now, of course, there was, I don't want to cast that as like halcyon days, because there were a lot of issues there too. We still had a colonial system, and some states seemed to matter more, even though on paper everyone was juridically equal. So it's not that that system is free of defaults, but the practice-based methods of legal development certainly don't cure that problem. Powerful states are able to entrench their interpretations more than others. Now, we do see some hopeful signs of other groups of states trying to sort of counter the power of the two big blocks, the United States bloc and the China bloc, that China, maybe China, Russia, but China bloc. And that is, for instance, the Latin American Caribbean Space Agency to be based in Mexico is a new project that was also sort of set up to counter the dominance of these two main lawmaking streams. So one thing that smaller states can do is align with other ones, right? And get coalitions together, and their voices can be powerful in that way.
Wonderful. In that case, I think this is a good point to wrap up for the day. Professor Durkee, I want to sincerely thank you for your time, for sharing your research with us and answering our questions. Also want to thank all of our attendees for your attendance today. I think this was an excellent webinar to wrap up our series for the academic year, but we will be back next academic year to bring more discussions on space law research and international law more generally. So please tune in later this year, and I hope everyone has a great summer. So thank you all again. Thank you again, Professor Durkee.
Thank you very much. Pleasure to be here.